Well, good morning, everybody. Happy New Year. It is January 3rd, 2023. And we are, what number is this? Is this part?
I think it's 4.
Part 4, maybe part 5 of the read-through series for the proposed adult use cannabis regulations. This programming is brought to you by CANY, the Cannabis Association of New York, and the Rochester Public Library. We are continuing our digest of the proposed regulations, and the intention is to create a read-through experience that is kind of like a classroom setting that allows for a more digestible understanding of the regs. We're lucky to have two lawyers, two of the leading lawyers in New York State, helping us break down and understand these regulations. And the idea is that through this proposed regulation period, we're developing our comment. So we're in what's called a comment period, which there was these proposed regulations released by the state, and now it's up to us as individual citizens, professionals or businesses to digest these regs and then come up with our own opinions and or proposals that either support the regulations or request change. So throughout this reading process, we'll stop and chat about areas of concern. And this is an open conversation, so anyone who is live and in attendance, please feel free to ask questions. There are no wrong questions here. In fact, questions make this a little bit more of an interesting process. And if you're watching this recording, just know we are live on Tuesdays and Thursdays from noon until 1:15 until we are done with these regs, and we'll keep on moving forward. So I'll take a moment to allow my colleagues to introduce themselves as I'm preparing the PDF in the background, and then we'll go from there. Jason, I'll send it your way.
Thank you, Zach. Jason Klemick. I am the chair of the policy committee for CANY, as well as the cannabis team leader at Barclay Damon law firm. And I am on the NYSBA, New York State Bar Association's Cannabis Law Committee, and I head the tax committee for that. Elise, passing on to you.
Jason and I have very similar overlap. I am on the policy committee for CANY. I am executive leadership for New York State Bar Association. I work for 2 women-owned businesses up in Lewiston, New York. MJI Solutions is the consulting leg of that. So happy to be here.
Great, thank you so much. And my name is Zach Sarkis. I'm the chair of the education committee, also working alongside the Rochester Public Library and helping them build out their programming. Small business owner, work on a license cultivation project, as well as been exploring the seed to sale process through the world of CBD. So kind of have my hands in the production side of things. It brings that perspective, and happy to be accompanied by these legal geniuses. All right, so let me just share my screen here. So again, anyone who's in the viewing room, feel free to drop any questions or comments in either the Q&A or in the chat. We will keep an eye out on that as well. And so we are picking up on section 120.7, and I think it's actually technically 120.7D. And Jason, if you could just give a high overview of what 127 is, as I'm getting the screen together.
Oh boy. All right, let's see. It was the application, eligibility, and evaluation. So this was all going through what's going to be included in the application, what they need to submit, how they're going to review it. I think this touched on some prioritization in the applications, though I think more specifics come in one of the later sections. So we had kind of rounded out last time the general requirements under the application for, once you submit for submission.
Great.
It's obviously it's such an important section too, because I think there's a lot of unknown stuff out there about what you're going to need to apply. So, if you're bringing on consultants, if you're bringing on people who you're going to have to pay up front, what do you actually need to put down with your $1,000 application fee before you get to the provisional license approval, which is obviously a much more concrete situation where you can say, hey, I have a provisional license in hand. I'm way more willing to put money down because I know I'm actually going to be operating, as opposed to having to put all that up front on an app, which is obviously very expensive. So
Yep.
this is a good section.
Yeah, absolutely. Cool. So I think we're at the tail end of this section. So if you need a repeat, catch the last probably 10 minutes of our last recording. And we'll pick up on section E here. So I'll take the reins, and then we'll keep on keeping on. So section E says, if an applicant is approved by the board, the applicant shall be subsequently issued a provisional license. Such provisional license shall be subject to reasonable conditions specified by the board. So there's that provisional license concept. If a provisionally approved applicant fails to satisfy the conditions determined by the board, the application will be deemed incomplete and the provisional approval will be revoked. Provided, however, that the applicant may request additional time and shall have the opportunity to demonstrate to the board a reasonable documented effort to complete the conditions required by the section in a time frame set out by the board. If the applicant fails to satisfy the conditions and is unable to demonstrate a reasonable documented effort, the applicant will not be refunded of its licensing fee. So that being said, you get your provisional, you still got to get some stuff done. If you're having trouble getting stuff done, you can request an extension, but you have to show a really documented effort of you trying to get those things done. Otherwise you risk the loss of your application.
And
your
you
license.
have 12 months to get it done once you receive your provisional license. So you have a year to finish that out.
And we saw this sort of with the card applications, where you kind of had this almost provisional application where it was really just kind of the background information, true party of interest stuff. And then once they selected you as a licensee, that's where all of these plans needed to come in, and like kind of the real work began, because it was creating as opposed to just kind of reporting some information. So they seem to kind of carry that concept over.
Great, thank you. So 120.8, application for an additional license or license type. So a licensee seeking to apply for any additional licenses or license types shall do so in a way and form and manner required by the board, and remit the required application and license fees set out in section 120.4. For additional license type authorizing by cannabis law and in this chapter, different than the one the licensee currently holds, the licensee shall file an application for the additional license sought and shall pay the application and license fee for each additional license type sought. For an additional license of the same type as the licensee currently holds and is authorized pursuant to this chapter and the cannabis law, with no amendments or changes to the business information, ownership, true party of interest, the licensee may file an abridged application in a form and manner required by the board for the additional license, or to amend the change of a current license type to another license type, the licensee shall submit an application for the new license type while maintaining their current license type. 3, to amend or change a current license type to another license type, a licensee shall submit an application for the new license type while maintaining their current license type. Sorry if I already read that one. So B, a licensee may maintain its current license type during the processing of the application for a new license. If the license is prohibited by cannabis law from holding simultaneously their current license and the new license sought, then the licensee shall be required to provide notice to the office in writing that the licensee is surrendering its current license prior to the issuance of the new license.
So wait, so let's just pause this real quick, Zach. This is really important for anybody who's an AUCC or AUCP at the moment. Obviously you can maintain as a conditional license holder through once your application for a new license, and then once you've actually received a provisional, it sounds like you have to then surrender your current license. This obviously translates into any other license as well, but this is very applicable for anybody who is in these conditional periods.
Yeah, and it's a big thing too, you know, depending on when you get your application or your preliminary license for your formal license. Let's say you're an AUCC, an adult use cultivator, and you know, you have this preliminary license and you're cultivating next year. Let's say you get your provisional license for your actual license, before you're done harvesting. You know, does that mean you have to cut down your field, for example, before you can act? Like, you have to like terminate all production under your AUCC. So timing is everything when it comes to these, in this particular situation, application, getting a provisional license to transition into full formal license. So it's a little complicated and definitely unnerving for folks.
Especially like for those who are going from like outdoor to indoor, right? Like it's much different for people who are changing their license types from what they currently have as infrastructure to quite possibly different infrastructure. So
totally. Yep. Any licensee providing such notice of surrender to the office shall provide a copy of such notice to its workforce no later than 30 days prior to notifying the office of its intention to surrender the license. Provided, however, if the licensee has more than 50 employees, the licensee must notify their workforce 60 days prior to notifying the office. If the application pursuant to the section is denied or non-selected for a license, the non-selection or denial shall not affect the licensee's current license. The office may prioritize the review of an application request for an additional license, provided that the application already has a license. So then 120.9, issuance of a license. No license shall be considered issued or effective without final approval of the board. An application for licensure under this part shall only be approved by the board if, one, its complete application has been submitted to the office along with all necessary fees. Two, the application demonstrates to the satisfaction of the board that the application will operate in accordance with Article 4 of the cannabis law and this chapter. What's Article 4 again?
That's the adult use portion of the MRTA.
Great. 3, the application is ready, willing, and able to properly carry on the activities set forth in the application. And 4, the applicant is of good moral character.
that's interesting that they're doing super vague.
The good
moral character. Yeah.
They
It's
look
kind
at
of like
that.
a catch-all. It's a bit of a catch-all for people for if you have any crimes or if you haven't like paid child support, if you're, you know.
That's exactly it. I mean, if you look at the good moral character portion, it's in one of the, I mean, they do talk about any type of criminal behavior or even like pending and things like that, not even just convictions. I think it was actually just arrest too, and including like, you know, when you're younger and things like that. So that it could be an issue.
Could be impacted. Yeah. Impacted.
We do have a question. I don't know if we want to answer it right now, Zach.
Yeah, let's check that out. So the question is from Perry and says, can an applicant initially apply for several different types of licenses and then if approved decide which one they will pursue, and for example simultaneously apply for retail and cultivator? If approved for both, then they pick one.
I don't think there's anything necessarily prohibiting that. I think that I do know when we did other when like the card licenses and stuff like that, they did mention specifically on there, are you planning a TPI in any other applications even? So they will connect all the applications together. I don't know that would necessarily deny you. You'd have to pay all the application fees. So, you know, $1,000 a pop or whatever it is. And then once it comes up for approval, I don't know how you would communicate with the office on that, like give it priority. Because, you know, if they said, well, you're technically eligible for retail and cultivation, I don't know how you tell them which one you want, because one would knock you out of the other. So that's kind of an administrative thing that I don't think is really covered in the regs. Then we'll just kind of have to see how that plays out.
Just to keep going on the good moral character, Jen asks, does bankruptcy count as bad moral character typically?
So I don't think so. When we talk about typical moral, bad moral character, it's like a lot of times it's crimes where you've lied or stolen, you know, or you're not, you know, they have talked about child support payments in the past, and failing to pay that. I haven't seen anywhere in the definitions or even like for us as lawyers who are also judged as for bad moral character where bankruptcy has counted. And I do think they define it later on. So let's take a look at that. But I think in my opinion, I don't think it's going to be a factor of bad moral character.
And but there is, I agree with that. There is one thing, and I cannot remember where it is in the regs off the top of my head, but they do mention like financial negligence or something like that could impact once you have a license. So they do kind of tie the concept in there, but I don't think it is applicable to the moral character.
I mean, if you were going after businesses that went bankrupt, you'd have like no large scale businesses. So many people.
Valid. All right, cool. So part C, the board may provisionally approve an applicant, which shall convert into a final approval upon the board's receipt to its satisfaction of all necessary documents to meet the outstanding conditions and contingencies resulting from the application process. Provided, the board may deny an applicant that has not submitted all necessary documentation to the satisfaction of the board in a timeline prescribed by the board. After receiving provisional approval, the applicant shall be given 12 months, there's that 12 months, to fulfill and submit any withstanding information to obtain the final license approval, unless otherwise approved by the board. D, licenses under this chapter shall be effective upon the date of the provisional license approval converts to the final approval and shall specify the following information: the name of the licensee, the address of the real property or the applicable.
That's important, right?
Okay, yeah, go.
So number 2 is not the name, obviously, but the address is very important because you don't have to have an address to apply. I think you just have to put your locality in which you intend to operate. That's huge for people for not having to engage on leases or buy property before you have a provisional license.
Yep.
But in the same token, it is going to be now a countdown for you to find property in your locality. And this is going to be a bigger issue for dispensaries than it is for, I think, grows and processing facilities because of the restrictions, which we've already read on about how far away you have to be from other dispensaries, which localities have already opted in, that kind of thing. So really dispensaries, you'll have 12 months, but you're going to need those 12 months, I think, to find a location that really suits you for within all those zoning regs.
Totally. Furthermore, they'll need the name of the contact person, license type, and the list of activities permitted to be performed under license for each licensed premises, date of issuance, date of expiration, the license number. Licenses shall not be transferable or assignable without prior written approval of the board, including without limitation to another license. A change in majority ownership or controlling interest in the license or a person holding the license shall constitute a transfer of the license.
And that's another important one because we see that right now with the AUCCs and having to hold on to 51%, but they want investors. So, and right now the OCM doesn't have an official process on how to do that. So hopefully that will be coming, but it's important to understand that you can't just transfer the license by selling 51% of your entity or 100% of your entity. That is a change in ownership that has to get approved.
Yep. F, to obtain approval by the board for the transfer of a license, the transferee shall submit an application to the office in a manner prescribed by the board, demonstrating an ability to operate the license in compliance with this chapter, along with the application fee pursuant to section 120.4 of this title. G, the board may deny an application for the transfer of a license if the applicant fails to demonstrate that the transferee will comply with all the requirements of this chapter, or if the licensee has a record of poor performance, meaning 2 or more category 1 and 2 violations pursuant to part 133 of this title within the past 2 years. H, the licensee may amend a license or add or delete permitted activities or change the location of the licensed premises by submitting a written request to the office along with an application fee pursuant to 120.4.
They're just gonna keep getting you for those $1,000.
Yep. So just to be clear, that means anytime you make an amendment, you have to resubmit, and it's $1,000.
Yep.
Or 500 if you're a social equity applicant.
Right.
Yes. A request to add permitted activity shall be reviewed by the office in accordance with section 120.7 of this title. J, verification. The office may conduct random or scheduled verification inspections after a license has been issued to determine if the plans submitted to the office meet or met the minimum requirements as described in this chapter or in guidance as may be issued by the office. And then 1, in the event that the board determines the plans or evidence submitted under this part do not meet such minimum requirements at the time of the application, the board may deny renewal of, suspend, cancel, or revoke the license in accordance with Part 133 of this title. And 2, in the event that the board determines that a licensee fails to adhere to the minimum requirements described in any plan or evidence submitted on the section, the board may deny renewal of, suspend, cancel, or revoke the license in accordance with Part 133 of this title. Or oopsies. All right. Anyone want to take on license duration?
Sure, I'll do it.
Oh, go
Oh,
ahead,
you do it, Jason.
Wow.
If you want to, feel free.
All right, I'll go. All right, license duration. A license shall expire 2 years after the date it is issued. So just know that your license fee is only good for 2 years. A licensee may surrender its license prior to the expiration date of such license. However, the surrender of the license shall not automatically invalidate or terminate any pending violations, charges, fines, or proceedings commenced against the license. So if you're in hot water, just because you say, hey, I'm canceling my license, doesn't mean you're not on the hook for any of the pending violations or charges. License renewal. So any application to renew any license issued under this part shall be filed with the office not more than 120 days nor less than 90 days prior to the expiration thereof. If a renewal application is not filed at least 60 days prior to the expiration thereof, the office may determine that the license shall expire and become void on such expiration date. So after, within your 2 years, you better be reapplying to maintain good standing of your license.
And you have a month window to do it, essentially.
Yeah, exactly. 30 days. So no more before 120 and no less than 90. So it's like that random, 119 days to 91 days, basically. Renewal application shall be accompanied by another non-refundable application fee and license fee as set out in section 120.4 of the section. This is very important. Your license fee is going to be required for year 2. So when you're putting your return of investments down, make sure you have on your year 2s an additional, and it could be a couple $100,000 depending on which tier you're going with for cultivation. So something to really think about. The application for renewal shall be submitted to the office in a manner prescribed by the board and include such information as the board may require, including but not limited to the following evidence or information showing. Okay, here's what's important. The licensee contributes to communities and individuals disproportionately harmed by the marijuana prohibition laws. This is a community impact plan that you'll have to fulfill. You're going to most likely submit a community impact plan when you apply. You have to show that you met that community impact plan when you're renewing. The license has an executed labor peace agreement with a bona fide labor organization. This is an LPA is just showing that you agree to letting a union come in and speak with your employees. It's not necessarily you have to be part of a union. I will say though that all the MSOs that are in the medical market have their employees are part of the union. So the racial, ethnic, and gender diversity of licensees, employees, and owners, you have to show, did you make a concerted effort to get more diversity and more different genders in your workplace? The licensee has adhered to the social responsibility framework set forth by the office, compliance with building and fire codes, zoning ordinances, and business licensing requirements, or any other as code, ordinance, or requirement determined by the office. An update on the information is outlined in paragraph 5 of subdivision B of section 120.7 of this title.
There's a question by Stephanie. Do all licenses need a social impact plan or just non-social equity?
No, everybody needs a community impact plan.
Great. We'll get to the specifics a little bit further down, but yeah.
Yeah, I was going to say, confirm with me too, Jason, isn't the community impact plan due upon application?
I believe
not due on
that's
provisional.
correct.
Yeah, so you guys, the what's due on application versus what's due on provisional is very odd. It's like energy report, community impact plan, like social responsibility is due on app. And then like your operating plans, all that stuff is due like during your provisional.
So there's a lot of forecasting that's got to be done. And, particularly on the community impact plan, I think you want to be realistic too. You don't want to commit yourself to, we're going to fund $1 billion to the, because then you just committed yourself to something that's probably unsustainable. So it's going to take a lot of, I think, work to get those community impact plans where, they are impactful, but also the business can sustain itself.
Yep.
Absolutely. So, the licensee has no outstanding filings, reports, fines, or deficiencies with the office in the operations of an adult use license and any other information requested by the office. The board shall determine whether to renew an applicant's license based on relevant factors in this section and section 120.7 of this title. If applicable, the licensee shall provide a statement that there have been no amendments or changes to the license premises since the license was issued, accepting any amendments or changes that previously received approval from the office or board as applicable. Okay, guys, this is very important. You're going to submit your operation plan during the provisional license. You're going to outline where you're growing, and this is, or where you're selling, or where you're processing. And at the point of renewal, if you have expanded post what you originally submitted for, you have to make sure you're updating in this renewal period that anything has changed since the last time you were applying with the board. An applicant may not apply to renew a license if the license has been canceled, suspended, or revoked. License denials. The board may deny an application for license, including renewal applications, if the application does not meet the eligibility requirements in section 120.7 of this title. The applicant or their true parties of interest have a history of violations relating to its operation of owning or operating a business.
Just one point, operating a business, not the business. So I think that's a very important distinction.
Well, especially too, you have to submit obviously all of the businesses you're part of. All your true parties of interest have to show what businesses they are part of in the application period, and even showing how those businesses treat their employees. So if you are currently operating a business, you have to show what you pay minimum wage to your employees, what your diversity amounts, what your retention rates are. So you have to submit all of that. If you have a history of violations in those companies, that's going to impact you quite a bit. It also, you got to remember, and Jason and Zach and I have talked about this a lot. True party of interest is going to be the most difficult component of this app. Who you're taking money from, who's part of your business structure, the understanding what those people are actually a part of is going to be a whole process in itself. So, whomever you're engaging with to be part of your business, you really have to understand what their interests are in other cannabis businesses or businesses in general. The source of funds identified by the applicant to be used for the acquisition, startup, or operation of the business is determined by the office to be questionable, unverifiable, or gained in a manner which is violation of law. I think this is kind of brutal because you're encouraging legacy market, and then they have a clause like this. So I think this is beat, to be honest with you. But I'm sure somebody will put a comment in there that is way too vague when you want a legacy market to be included. The applicant fails to submit information or documentation requested by the office during the application and evaluation process, including any supplemental documentation subject to the applicable cure period set forth in section 120.19 of this title. The applicant makes a false representation or fails to disclose a material fact to the office and therefore may be subject to prosecution under section 190.25 of the penal law during the application process. The applicant or any true party of interest of the applicant is determined to be not of good moral character. Okay, this is an issue now. So now, not just you, the applicant, but if you have any business owners that are part of any true party of interest that might not be of good moral character, that's a big issue. And that's a very, again, who are you putting as part of your license is going to be the biggest question for everybody that is applying.
We did jump over I was scrolling a little fast. Number 6, the applicant or any true party of interest of the applicant is prohibited from trafficking cannabis pursuant to section 137 of the cannabis law. And I don't know what that is, but
those are it's restrictions like you basically committed fraud or you were convicted of selling drugs to minors, things like that. Like there's specified offenses, and they're pretty minimal, like in terms of like there's not a lot of them, and I think it's within the last 5 years or 10 years or something like that. So they do put a look back period on it. It's not ever.
The applicant or any true party of interest that the applicant has outstanding violations, fines, fees, payments, or other indebtedness assessed by them by the state or federal regulatory authorities or any local municipalities. The applicant or any true party of
Sorry.
interest, oh, it's okay, of the applicant has a history of giving away or selling cannabis or cannabis products in an unlicensed or unauthorized manner since the passage of the act through a brick and mortar retail storefront, vehicle, or membership club that sells cannabis or cannabis products or charges customers a membership or admittance fee or otherwise poses a legitimate business. I'm going to be honest with you. The membership club, I think, came out of an event we had in July with the Roaring 420s Lounge, who made this exact point to Chris Alexander that they were not an illegal business. And Chris they were asking Chris that. So I feel like this is a very pointed point right there. And mind you guys, this is really only pertaining to people who are getting caught, right? Like that's why enforcement is such a variable component of this, because it's really just the 50-ish cease and desist letters that have to worry about this right now.
So is that the history? Are we going to define history as getting caught, or is history meaning like there was notes about you at one point? To what degree is the history actually counted for?
I think it's the notes kind of thing, because like in looking at in hearing some things on the card applications, I think there were certain parties that didn't get licenses because a quick Google search was able to connect the dots enough for OCM to say, we don't like what that person was engaged in. So I think, if they're able to connect the dots of who you are to one of these illicit type businesses, I think it poses a threat to your ability to get an application. I don't think it's just, you got to cease and desist and then you're out of the game.
So obviously you, this is a really big eye-opening for people who are in the papers, right? People who are going to the media saying that they're selling their product, there's quotes about you participating in the illicit market. Those people should be, even if you haven't received a cease and desist letter, just like Jason said, if it can be verified that you were part of the illicit market through any of these streams, you're in a bit more trouble there. The applicant or any true party of interest of the applicant has or previously had an unapproved interest in a license issued by the board other than an interest exempt from disclosure pursuant to this chapter. The proposed licensed premises is located in a location prohibited by cannabis law or state laws or regs, except with respect to licensed premises previously approved. So if this is that clause, if your locality intends to opt out after they've already approved areas in which within that locality that they have allowed. So like say, for example, and this wouldn't happen, but like say Buffalo decided after the application window that they wanted to opt out, you would still technically be approved because it happened during that window which they had opted in, which is what that means. If something's up and running, you can't just say, oh, sorry, we're not allowing it in the local authority anymore.
Totally, which is good. Good safety rails.
Yep. Applicant fails a pre-licensure expansion of the premises by the office unless the applicant shows good cause for office to perform an additional inspection. Applicant determines a pattern of deficiencies, including but not limited to refusal or inability to produce records or reports as requested by the office, failure to correct deficiencies or violations in accordance with an approved corrective action plan, deviation from regulations or standard operating procedures so as to jeopardize the quality of cannabis or cannabis products, and refusal to provide office employees with access to the licensed premises. So knowledge of sale of cannabis or cannabis products not meeting the requirements of this chapter, general failure to comply with the requirements of this chapter, and any other grounds for denial as determined by the board. In addition to the aforementioned, the board may specifically deny any renewal application based on the additional criteria, including but not limited to if the applicant fails to maintain an LPA with a bona fide labor organization, the applicant fails to provide documentation of a racial, ethnic, and gender diversity of the applicant's employees or owners, the applicant fails to submit a renewal application not less than 60 days prior to expiration of the license term, The applicant fails to provide evidence of the execution of their plan for benefiting communities and individuals disproportionately impacted by enforcement of marijuana prohibition and any other grounds for denial as determined by the board. Jason, you want next section?
Sure. All right, reapplication after license denial. An applicant whose application was denied or a licensee whose license was canceled, suspended, revoked, or not renewed due to one or more of the provisions in paragraphs 1 through 4 of this subdivision may reapply at any time after the failure or disqualification is cured. Failure to satisfy the age requirement of the cannabis law, after which reapplication is permitted only upon obtaining the requisite age. Determination that the applicant was a person prohibited from trafficking cannabis, after which reapplication was permitted only upon a change in circumstances whereby the applicant no longer meets the standards as a person prohibited to traffic cannabis under section 137. And I did check, it's 5 years. So if you had applied at 4 years, you would be denied, but after the 5th year, you could then reapply and you could qualify.
Interesting.
Any statutory or regulatory provision that is subsequently repealed or modified, after which reapplication is permitted only upon a showing that the subsequent repeal or modification of statutory or regulatory provisions obviates the ground for denial or revocation and justifies the conclusion that the prior determination should not have been a basis for denying an application, or the chosen premises was in a location that violated the cannabis law or local ordinances, after which reapplication is permitted upon securing a new location. An applicant seeking to reapply pursuant to subdivision A of this section shall file with the Office of Petitions stating that with particularity how the failure or basis for the disqualification has been cured. Except as otherwise set forth in this part of the cannabis law, an application an applicant whose application has been denied or a licensee whose license has been canceled, suspended, revoked, or not renewed may reapply after 1 year. No application whose license has been canceled, suspended, revoked, or not renewed within 1 year that is substantially the same as a previous applicant by way of their true parties of interest, ownership and control structure, or any other consideration the office determines to be of interest shall be considered for another license. The new application shall include submission of sufficient evidence demonstrating that the factual circumstances upon which the denial or cancellation, suspension, or revocation was based have been cured to the satisfaction of the office. Notwithstanding subdivision C of this section, if an applicant that has qualified as a social and economic equity applicant is denied for a license but is otherwise eligible, the applicant may be considered by the office for administration into the social and economic equity incubator program as articulated in the social and economic equity plan and subsequently reapply after completion of the incubator. 120.14 voided applications. Upon failure by an applicant to respond to the office's request for information or documentation pertaining to their application within the time required by the office, the application may be deemed void. 120.15 withdrawal of an application. Prior to the board issuing or denying a license, an applicant may withdraw an application by providing the office written notice of such withdrawal. Upon the receipt of such notice, the office will cease processing the application. If the applicant has previously withdrawn an application, the office may refrain from processing any application submitted by such applicant within 1 year from the date of such withdrawal. No fee or other payment relating to an application shall become refundable by reason of withdrawal of the application unless the office determines otherwise. 120.16 standard for reviewing disqualifying offenses. For purposes of determining whether an applicant qualifies or is suitable for a license under the cannabis law, including but not limited to with respect to section 137 of the cannabis law, this part, the following shall apply with respect to offenses of an applicant and any of its true parties of interest as defined in part 118 of the title. All conditions, offenses, violations, and conduct that are construed to include New York state law or similar laws of other jurisdictions, provided, however, this shall not be applicable to marijuana-related offenses. All criminal disqualifying conditions, offenses, violations, and conduct, including the crimes of attempt, accessory, conspiracy, and solicitation. Juvenile disposition shall not be considered as a factor for determining qualifications or suitability. Where applicable, all look back periods for criminal conditions, offenses, violations, and conduct commence on the date of disposition, provided, however, that if disposition results in incarceration in any institution, the look back period shall commence on the release from incarceration. And unless otherwise specified in section 137, a conviction, offense, violation, or conduct shall include convictions, guilty pleas, and pleas of nolo contendere. A licensee and his true party of interest shall remain qualified or suitable at all times that a license remains in effect. An applicant, licensee, or true party of interest shall notify the office in writing of any offense or incident, including but not limited to offenses set forth in the section of 137 of the cannabis law that would result in denial of a license within 10 days of such offense or incident. Failure to notify the office may result in a revocation, suspension, cancellation, debarment, which means they will basically bar you from interacting with the industry on a business level, from a license, or any other penalty set forth in this part. So I think that's really important because you have to monitor your TPIs. So, and you know, you might just have passive investors, but sorry, I shouldn't use the word passive investors, defined term. Investors who trigger TPI but are not involved in your business other than they gave you money. You have to make sure that they don't violate any other law. And if they do, they need to tell you that immediately because you have to report it to the office within 10 days. That's
10 days is just so unrealistic too. Like, for example, say somebody gets a DUI. You think their first thing to do is like, let me call up my investment in New York and let them know that I got a DUI 5 days ago. It's just not practically, it's not realistic.
Yeah, that one, it's going to, I mean, if that stays in the regs, it's going to take a lot of compliance.
I mean, they should make that like 100 days. I just 10 is just egregious.
Yeah, it's even just thinking about the 10 days. Okay, so not only does there have to be a notification, but the notification has to be received, registered, implemented. So it's a high pressure on the OCM itself, let alone the person who's going through the motions.
You also got to really think about this, like somebody that you're taking money from, that's say they're out in, say you're getting money from somebody, even in New York City and you're in Rochester. Do you think that you can really remotely monitor that person if you're not like a friend and it's not like a very close relationship? I mean, you almost have to make sure that your investors know this every like couple months. If anything happens, you have to let me know because it's on the applicant, right? It's on you to make sure you know these things.
And the word incident is concerning because what is an incident? Like I could almost give them conviction because a conviction is a final event. But incident, I mean, if you were pulled over and your car was searched, is that an incident? Like
if you were falsely accused of something and you have to follow up with it just because you have to, it's like, is that an incident?
Right. I mean, that is very broad. And I mean, it could also just open the floodgates to OCM where they just get inundated because things happen to people like that, you know, they didn't even necessarily do anything wrong. It's just wrong place, wrong time, but that's an incident.
And also like obvious offenses are listed out, like they're part of section 137. So you have concrete referral on an offense. An incident is not defined. So it's super broad and more of a headache than a help.
All right. If the conviction or disposition record was sealed, the office may require the individual to provide proof from a court evidencing the sealing of the case or any other information that is determined by the office. 120.17 notification and reporting of business changes and amendments for the applicants. An applicant may update their application before it has been approved in a manner determined by the office.
Good luck with that.
Here's hoping they have an official process for that.
Yeah.
I really hope.
Sorry to all of our fans out there at the OCM. We love you guys. We just understand the pressure you're under, and it's really, really a lot.
Yeah, a process would just be wonderful for everybody. For OCM, for us, it'd be great. if an applicant is issued a license, the duty of ongoing disclosures for the licensee and its true parties of interest pursuant to this chapter shall continue throughout the licensing period.
Mhm.
Notification and reporting of business changes and amendments of licensees. Duty to report. Licensees have an ongoing duty to report any changes or amendments to their operations to the office. The licensee has a continuing duty to provide the office with up-to-date contact information and shall notify the office in writing of any amendments or changes to the mailing address, phone numbers, electronic email addresses, and other contact information they provide to the office. A licensee shall report to the office any amendments or changes to the cannabis business operations that are required in regulation and law. Any proposed material amendments or changes to the cannabis business for making a material amendment or change. Material amendments or changes include, but are not limited to, the following: amendment or change in any true party of interest, not including passive investors. Amendment or change in processing extraction methods. Amendment or change in any entity name or doing business as name. Any amended or changed name shall comply with all the requirements set forth in Part 128 of this title. Amendment or change to the cannabis business before or after licensure that was not part of the cannabis business application or site plan, including but not limited to all of the following: operational or method amendments or changes requiring inspection or pre-approval from the office under this chapter. Increase or decrease in the size or capacity of the licensed premises and the authorized operations of the licensee. Alterations of ingress or egress, and amendments or changes that impact security, fire safety, and employee safety.
What's the ingress or egress?
Entrance.
So, yeah, entrance and exits. Yeah.
So if
And this all goes to fire code, right? So you obviously in your provisional get an approval from your fire, your zoning, from your electric, any of the things for you to get a certificate of occupancy. And if they're altering that, that means you're operating your certificate to continue business.
yeah, so don't, put a sledgehammer through a wall, call it a door, and don't tell OCM about it.
Well, also processing is really important, right? Because like say you go from solvent based processing to solventless, it's a lot less necessary fireproofing and things like that, and storage, or vice versa if you go the other way. So extraction process are listed specifically for that purpose.
Mm-hmm. All right. Authorized amendments and changes. A licensee may make the following amendments or changes in a manner prescribed by the board and shall remit any additional fees as required for the amendment or changes, including any change in agreement or new agreement between a licensee and an existing or new true party of interest. Any change in control where an individual, corporation, or entity will be able to control the decision-making of a licensee, including but not limited to. Pay attention to this, because this has huge, and I'll tell you the exact scenario that'll come up. You have an investor that maybe doesn't even trigger true party of interest. They come in as a 10% owner that's passive, but this is very common in, outside of cannabis, is the investor will want final say on some big ticket items that could trigger this. And so you have to be very careful of that type of thing where you're, as we're going to see, contracting away the rights to control the organization or the right to exercise control over the business or other rights as determined by the board to a person or entity that is not a member of the governing body of the organization. So again, you have a big investor come in that comes in for 10%, gives you a lot of money and says, well, I want to make sure that if you sell off the company, I get a say on that before you just sell it off. That could trigger that provision. And you have to remember that now, that's going to require an amendment to the board.
Within 10 days.
Yeah. Let's see. Okay. The granting to make material business decisions or veto significant events, which may include, but are not limited to, any sale of all or substantially all the business assets, a merger or consolidation, a change in ownership or control, liquidation, dissolution of an organization, or any events as determined by the board. Again, those are super common in like operating agreements for an LLC. and are going to be negotiated provisions when you come in as an investor. So, be very aware of those things.
Yeah, you guys cannot just go and take an LLC operating agreement off of the internet and think it's gonna apply. This is where you're gonna have to have, attorneys or accountants or whomever really help you to vet out these clauses in your agreements, your bylaws, whatever your type of organization is.
Any mergers and acquisitions applicable, applications for additional licenses, hiring and firing of executive level officers, or other determinations made by the board. For licensees with less than 10 owners with an equity interest, anytime there is a new person with an equity interest in the licensee shall submit within 10 days an updated entity disclosure in the form and manner prescribed by the office with all holders of equity in the license. That's a real issue because it's very common to give your employees some type of small ownership. I'm not going to give you 10% of the company, but maybe you're a great employee and I want you to participate in the upside. So here's 1% or something like that. Now that's reportable to OCM within 10 days. So
That's only with 10 or less employees though, just remember.
Right, but those are small businesses. So that's just an added level of compliance for small business. And an attestation of such owners' eligibility to hold a cannabis license and an attestation that such owners have no statutory disqualifications that would bar them from being licensed. Licensees seeking to materially change their composition pursuant to paragraph 2 of this subdivision shall submit an application to the office at least 60 days prior to the proposed date of execution, acquisition, or transfer. In determining whether to approve such application, the office may set terms or conditions under which it may allow the continued operation of the licensee. Amendments and changes requiring board approval. So everything else was office. This is board. The following changes require board approval. Changes to the controlling interest of an entity, ability to control at least 50% of the voting shares of an entity, or the board voting shares, or the board's decision-making power of the entity. Amendments and changes requiring office approval. These require the office.
So let's just go back to one really quick. Just how it's written is really important, okay? So the ability to control at least 50% of the voting shares of an entity, that is its own subsection, or the board voting shares of the board's decision-making power of the entity. So that doesn't mean you have to have 50% of ownership, but if you're changing the board decision-making power scheme and the voting shares, that also has to be reported regardless of equity change. It's all about decision-making powers in your company.
And to tie it back to what we were talking about before, that's one of those investor provisions. Oh, I want to control the majority of the board because I'm funding you.
Yeah.
So yeah, all very important things that you got to just remember. You're always constantly updating the OCM on this stuff. Let's see. So these require office approval. Anytime a new TPI is added to the entity, not including a passive investor. Changes requiring background checks of the altered parties, which includes any time a new TPI is added to the entity, not including passive investors, and a change in the location of a licensee's licensed activities. Amendments and changes requiring notification to the office within 10 days. The following changes require notification within 10 days. When a non-shareholder true party of interest no longer maintains the position of a true party of interest. So that could be like an officer, a board member, or something like that. When a shareholder true party of interest who is not a passive investor becomes a passive investor. I don't know why they continue to use shareholder.
Yeah, I don't either. Yeah.
Right. Does that mean that it doesn't apply to LLC members? I don't really know.
Right. And on top of that, it's confusing because they should really use the language of officer or vice president, how it's listed out in the remember, true party of interest can get activated by a person holding a high decision-making power. So you fire your COO, you have to now report that to the board.
Or even if you had a consultant that triggered TPI.
Right.
That's reportable.
Yeah. 10 days you have to report that.
10 days. Yep. when a person lends greater than 10% of the licensee's capital. So despite the fact that they may just be a financier, if they give you enough money, you got to report that. And upon the death or removal from the license of a true party of interest who is not also a passive investor. So that's a bit onerous in my opinion. Like your partner dies and one of the first things you have to do is make sure that OCM within 10 days knows that, you know, despite the fact that your partner just died. It's a little brutal. All right. The circumstances requiring notification within 3 days. A licensee shall notify the office within 3 business days of becoming aware of, or within 3 business days of when the licensee should have been aware of any of the following: criminal convictions, charges, or civil judgments against the licensee or its true parties of interest in New York State, any other state, federal, or foreign jurisdiction. So basically on planet Earth.
You get held up in Germany. You're in jail in Germany. You're expected to have let your New York business know so they can report it to the OCM in 3 days now.
3 days. At least they give you business days, so if it happens over a weekend, you got to it.
Lucky you got some time, but
Oh my gosh.
Just moral of the story: try to get arrested on a Saturday. Disciplinary actions taken against the licensee or its true parties of interest by this state or any other state, federal, or foreign jurisdiction, including any pending action, and the initiation or conclusion of any new judgments, lawsuits, legal proceedings, charges, or government investigations, whether initiated, pending, or concluded, that involve the applicant or its true parties of interest. I mean, does government investigations include the IRS decided to audit me and I'm totally cool? It was just a random audit. Do I have to report that now, even though it has no impact on the license or OCM or anything? I mean, I think that's a government investigation. I don't really know. Failure to provide notification or reports to the office pursuant to the section may result in fines and or suspension, cancellation, or revocation of the license. If the licensed premises is damaged by a fire, flood, or other natural disaster, or other situations of local, state, or national emergency, or by a security breach, the licensee shall notify the office within a period of 24 hours. And the office shall have the authority to quarantine all cannabis or cannabis products for analysis and, if appropriate, disposal if found unfit for use. So if your premises is damaged by fire or flood, first call the insurance company, second call OCM.
Again, even just thinking about natural disaster or just things like out of hand, like the situation just happened in Buffalo. Okay, in that 24 hours, what you would have actually had to do instead of like unburying yourself is make sure you send that email out to the OCM to let them know that you're having, you're stuck in snow, et cetera. It's just like, oh, it's crazy.
Yep.
In 24 hours.
In 24 hours.
Let's see. A licensee shall not change the composition of a licensee, including but not limited to a transfer in ownership, structure, or control without notification of the board and prior written approval of the board. Failure to do so may result in penalties, including but not limited to civil penalties or suspension or revocation of the license. Removing a party from a license. Upon request to remove a party from a license, such a request shall be accompanied by the following: a notarized letter signed by both parties acknowledging the change and explicitly detailing the party losing ownership is aware of the effects of that change. A corporate resolution of the licensee authorizing the licensee to change the ownership of the licensee pursuant to and consistent with the Articles of Incorporation, LLC agreement, operating agreement. I don't really know what the difference between those two are. Bylaws, partnership agreement, or similar governing document, and the laws of the state of formation of the licensee, and an affidavit of a member of the licensee's board of directors, a managing member, general partner, or sole member as may be applicable, attesting that the undersigned is authorized to act on behalf of the licensee and that the submission of the change of ownership application premised on the corporate resolution constitutes a valid corporate action, or a determination by a court of competent jurisdiction, or a decision by an arbiter agreed upon by both parties. I'll just round out this section because I think this is pretty short. Unless, Zach, you want to take over.
I mean, what do you mean by round out? Just finish it off?
Yeah, because we got this, and then there's 120.20, which is severability, which will be one sentence.
Send it, Jason.
120.19 opportunity cure. If all material documentation and information required by this application form is not submitted, the application shall receive a deficiency notice from the office. The application shall have the stipulated number of calendar days as described in the deficiency notice to cure such deficiency as stipulated in the deficiency notice. Such stipulated options to cure may include, but not be limited to, resubmitting the application in its entirety, providing all material documentation and information required in the deficiency notice, or any other requirements set forth by the office. Applications that are still deficient after the opportunity to cure will not be considered. Upon receipt of an application deemed to be complete, the office will engage in no further communication with the applicant until after the selection process is complete. Severability, they can sever it if something is held invalid, and it doesn't affect the rest of this. There we go. That is part
Great.
120.
Great.
I think let's stop here, right, or no?
Yeah, it might be a good time to reset, just so then we enter in these next stages, and this kind of preface to the licensing process. So
And
I'm happy
did knock out 25 pages. So
that's advanced. Maybe we can open it up. Does anyone have any questions, concerns? It could be pertaining to what we just covered, and outside of that, happy to kind of just open up the Q&A. I'm going to stop our share here. Great. We'll give it a moment here.
I know there's some good questions brewing out there.
Always. So what are we at? I think we're probably at like in the 49 more days of the comment period, maybe a little
Jason
more, a
and I
little
were
less.
talking about this. You got a month and 10 days because it's February 13th.
February 13th is the end of the comment period. So again, anything that raises a flag, like these 10-day notices, we're saying like that's a place where I'm sure more than one of us will address that in our comments to the board or to the OCM.
It's a good question, Jennifer. Jennifer asked, for micro enterprises, so micro businesses, do they say what happens if you get more than 25 employees? That wasn't written in any of the.
I think that the 25 employees, that applies to like the delivery license. So I think you just can't go over 25. And if you do, that's probably grounds for revocation or suspension.
Yeah, and it's a 25 full-time or equal thereof with regards to delivery businesses.
That's a good question. That might be something that you submit for CANY for clarification or comment on for the licenses during this comment period. That's a good question though.
Yeah, and even within that too, if you get a license to deliver for your micro business, then your micro business, the delivery component of your micro business is held to the standards of a delivery license, which would be less than 25 employees. So it's kind of like looking at that as a subsection, its own standalone license within your house of licenses on this micro business.
Yeah.
And I mean, I think part of it too is really, why does that exist? And it's to prevent I think one company from like taking over the delivery of New York State, and B, like to prevent like the Uber Eats of weed delivery. So that's why they included that or equivalent to full-time. So, if you're just running a business like a dispensary, I mean, if you needed 20, like pizza places don't even have 25 delivery drivers. So like you'd be running a pretty big operation to have 25 delivery people.
Yep.
And we don't think the 25 people is for both delivery and operations of your micro business.
I haven't seen anything anywhere explicitly saying a number of employees on a micro business, but I may be missing something, but that would be news to me.
I'm going to see if I can find anything real quick.
Yeah, I don't think micro identifies 20.
So here's it for retail. I'll see if I can find anything for micro. No retail dispensary shall have more than 25 employees or the equivalent thereof, providing full-time paid delivery services to cannabis consumers per week under one license. So they're clearly segregating delivery from your retail operations.
Mhm.
So I
Also,
would suspect
25
micro-
full-time, like there's so much leeway to get around that, make everybody part-time. I mean,
Or the equivalent thereof, correct? Or does it not say it in that section?
Wait, what? Sorry, say that again.
The equivalent thereof, 25, it's 25 and or the equivalent of 25?
Or
full-time?
equivalent thereof.
Yeah,
Yeah.
I'm curious how they define
So,
that as well.
50
yeah,
part-time?
you could have 50 people at working part-time.
Yeah. Makes sense, Jen.
Yeah, those are the only, that's other than I don't know which section this is off the top of my head, but it's dealing with consideration for whether applicants have entered into a statewide or local bona fide building and construction trade organization for construction work on its license. That and what I just read were the only places in the regs where 25 is mentioned. 25 employees.
Okay. Okay, any other questions? See everybody. Are we doing it Thursday?
Yep, Thursday. So we're Tuesday, Thursday, moving forward. Noon till 1:15, depends on how fast we fly. Next time we're going to pick back up on part 121, social and economic equity and adult use cannabis. Going to be super interesting.
Age 100 too. It's a
Page
good.
100. Yeah. Good start.
Cool.
All right, all. Have a great afternoon. Thank you so much, everyone who's watching this live and everyone who's watching the recording. We will see you all soon.
Bye.